we got distracted there for a second. What were you saying? And by the way, Benjamin went ahead and clicked live. So hi, everyone that's already watching. You're a little early, but that's okay. We're just having a little conversation here with Craig, the attorney. So Craig, you were telling me about the Illinois stuff that came out with regard to hybrid appraisals. Why don't you enlighten me a little more on that?
Yeah, this is an interesting one. And what I can tell you kind of in the short term on this one is, we're closely monitoring the situation here as well. So frankly, we don't know a lot. The other night, Tuesday evening, if I recall correctly, there was a posting on an internet forum where an individual who I believe is an Illinois appraiser commented that she had received an email from Brian Weaver, the state's appraisal coordinator, basically explaining in some way, shape, or form problems with AMC's ordering hybrid or bifurcated appraisals here in Illinois. And that quickly took on a life of its own and snowballed to claims of, yep, that's correct. Hybrids are illegal in Illinois.
And news alert, illegal. I'm committing a crime.
Yeah, and so that was a bit of cause for concern on our end. Certainly because, without ever naming names, we are absolutely aware of appraisers who may or may not be clients of ours who are taking on these sorts of assignments. And so immediately there was some cause for concern there as to what is the position. Has the state of Illinois actually taken an official position on all of this? As we sit here right now, the state itself, the regulatory agency, IDFPR, has not put out a news brief or a bulletin or anything along those lines. So far as I can tell, we don't have an official statement by the state agency or by any state officials on this one. But this issue kind of coming right on the heels of, many people might be aware of the fact there's a lot of discussion regarding hybrids and the state of Maryland right now, and whether Maryland is also taking a position and either limiting or outright prohibiting those sorts of assignments. We've been talking about hybrids now for the better part of really the last couple years, I think.
Yeah.
And we're seeing more of this. I think we're seeing more of these types of assignment orders come in for a wider array of assignment types now. I think originally there was an extremely limited use for these types of products. I think we're seeing that expand, and there's arguments kind of on both sides of the aisle here. There are those who are full-throated in favor of the idea that, hey, it's another product, it's another tool, it's more types of work that an appraiser can do, and the counterpoint is, there's also aspects of this appraisal. What is really, everyone's getting hung up on the idea of the third-party inspection. And is there some kind of limitation or prohibition on non-appraisers performing that inspection? Is that the hook here? Think of USPAP, right? Think of the third exposure draft we're looking at, or any of the exposure drafts. We're going to have a definition of inspection inserted into USPAP next cycle. And I think one could probably argue pretty cogently here that the reason the standards board is seeking to define inspection at this point is at least in some way related to these hybrid or bifurcated reports, where inspections are potentially being performed by non-appraisers.
Somebody else. That's going to clear it all up, I'm sure.
Every time.
And I'm as a practitioner, I'm torn because I grew up in the roots back on the typewriter day. We typed our appraisal reports on a typewriter, for crying out loud. So I've been around the block a day or two. And when I was in this business, when that's all I did every day, it was, I wouldn't even do it drive-by. I got to see it. I got to smell it. I got to touch it. If I'm signing my name on that, by gosh, I want to know, I want to know what I'm developing an opinion of value of. And I changed my position a little bit on that finally, and thought through that and thought, well, I do new construction, and I don't know what that's going to look like. When I have an idea from plans and specs, but I mean, how many builders never deviate from plans and spec? I mean, they almost always deviate to some degree. If I'm appraising a hotel and there's 400 units, am I going in all 400? Probably not. So maybe there is an opportunity, and I don't know how I feel about it. I have mixed feelings on it.
Hey, Bryan, look, man, I remember back when there was I think it was a 24 unit apartment building or condo building. And, you know, the appraiser, I think, ultimately did 30 different appraisal reports on that 24 unit building. He didn't go inside a single unit. You don't always have to, right?
Wow. Yeah. Yeah. Well,
example, I'm sorry.
Yeah, yeah. And then the same token, I could put photos up right now for our viewers. I was doing a Fannie Mae foreclosure many years ago. It was a manufactured home, and from the street, I mean, it looks fine. You go in it, and it had can I say mildew? Okay, it was mold. Okay, it was riddled throughout the whole house. The walls, the chair, the personal property chair sitting there had mildew or fungus this thick on it. And Fannie Mae actually called me and said, why were you in that house? You should not have been in that house as long as it took you to get the photos of the interior that you got. So please be safe. And I use that in some of my in my live classroom settings where I demonstrate, hey, be safe when you're out there. But you know, it would have been a completely different picture. And I think it's all a matter of risk, you know. For the client, is it riskier to do a drive-by than a full interior by the? Absolutely, there's more risk. Is there more risk with doing a desktop than there is a drive-by? Absolutely. Is there more risk with a hybrid? Possibly. But if your client's willing to assume that risk, I don't know. I don't have all the answers, but we're not going to resolve that today. And really our topic's on Workfiles, but it is interesting. We're still about 4 minutes away from the official start time. So if we've got some viewers that have hopped on earlier and kind of watching Craig and I speak about really anything and everything before we get on today's topic, hello, welcome. Glad you're here. We've got about 4 minutes until we actually start. We're just bouncing around talking a little bit. Craig, I got to spend at least a little bit of time with you when I was in Chicago recently. We came up and saw the Chicago Bears kill the Green Bay Packers, and that was a great game we got to see. And you and your bride were nice enough to join us for an adult beverage or two and show us around your great city.
Yeah, I was able to meet up with you at one of the finest establishments in all of the city of Chicago. That's a miss for everyone.
I did not pick that location, by the way. But yeah, and I need to come up and see you again. I know you want me to meet some folks, and I know them, but we've got to arrange that, get that on the calendar. But where are you going to be coming up after today's broadcast? People are going to want to reach out, touch you, call you. Have the opportunity to hear you speak at a venue, I'm sure, because you do a fantastic job. Where are your travels taking you in the next several months?
Well, for the next little bit of time, I'm going to have my head down for just a touch because we actually do have a series of trials up. I know people that watch this broadcast might be shocked to learn, but we even do practice a little bit of law around this firm on occasion. And so in order to keep the lights on, we're going to go do that for just a little bit. Sure. Shortly thereafter, we are actually getting into the continuing education cycle here in the state of Illinois as well. The last go around here in Illinois, there was a movement on some of the deadlines to complete continuing education, and 2019 is a licensure renewal year for folks here. So in the spring months, ICAP, which is the state's coalition here, just going to give my coffee mug shout out to ICAP folks. Join your state coalitions, folks.
Get involved.
Get involved and do things. They're going to start their seminar series a little bit early this year. So the first one of those is going to be coming up in March, to be followed by coming to join you nice folks out in Salt Lake City for the ACTS conference. I look forward to seeing you guys there. Right. Peter Christensen and I are actually going to be presenting together at that one. That should be good. I always like working with Peter. He's the information he's able to bring to the table is just fantastic. Yeah, so we'll be joining you for that one.
Those of you that don't know Peter, he is lead counsel for a E&O insurance carrier. And does a great job. He speaks very, very often. So it'll be exciting to see both of you guys kind of tag teaming it.
Yeah, it's fun. You know, we have not had an opportunity to do that now in probably 4 or 5 years.
Mm,
We had done some stuff with the old NAIFA chapter here in Illinois, and we had actually this. I think it does go back about 4 or 5 years now. We had put on a full day seminar through the local chapter here with Peter really being able to come to the table with just fantastic volume of all the national facts and figures and statistics on liability and claims.
mhm.
And I was kind of the hype man off on the side of the stage, but I was able to do the local flavor of, here's the anecdotal stuff of what we're really seeing on the ground here in Illinois,
Sure.
and that sort of stuff. And same idea with the state of Wisconsin. I know we're going to be going up and helping the Wisconsin chapter, the Appraisal Institute, out with something here in the spring as well. My partner Charlie and I, we're going to go do that. So we're bouncing around a little bit, but one of the ones that's definitely a blinking light on the calendar right now is coming out to Salt Lake City here in April and joining you fine folks. Looking forward to that.
Fantastic. We are honored to have you be part of that. Hey, guy, it is 10 o'clock, so we're actually going to get started. Good morning, appraisers. My name is Bryan Reynolds. This is the Appraisal Report webinar brought to you by the fine folks of Appraiser eLearning. We're excited that you're here today. I'm super excited for my regular guest, Craig, that's willing to join us pretty much anytime I call, except when he's in court. So we're excited to have him today. We're going to talk about Workfiles. We're going to talk about USPAP. We've sent a survey out. I'll give you the results of those surveys. I'd like to remind everyone, all of our sessions here at the Appraisal Report webinar are recorded. So if you're unable to watch this broadcast in its entirety, you can click over YouTube, click on our channel, and catch any of the videos that we have. This one will be available pretty soon after the live broadcast. You can go right back on there and click and watch the entire recorded version. That being said, if you would like to be a guest on the show, or if you know someone that you think would be an exciting guest, give us a call. Mr. Jim Park from the Appraisal Subcommittee will be on next month, and we have a surprise guest coming up in March talking about trainees. So we're excited about the next couple of months. While you're on the YouTube channel, go ahead and click subscribe right now if you don't mind. Click subscribe. That gets you as a member of our YouTube channel, and it keeps you in the know. We have these broadcasts once a month, the fourth Thursday of every month. And the best part is they're free. It's our way to give back to you. We hope that when you need some education occasionally, you remember us and send some love our way. What else? There was one more point I wanted to make, and it just flew right out, Craig. I looked down at you, and you looked like you were bored listening to me rattle on, so it just flew out. I'm sure I'll remember it. So we're going to go ahead and get started on the topic. Craig Capilla is my special guest today. He is an attorney in the state of Illinois. And Craig, I'd like for you to introduce yourself to folks. I mean, we don't need your entire CV, but I think people would be interested to know what your background is when it comes to real estate appraisals. I mean, you were kind of on the dark side there for a little while. And so tell everybody about what you did and what you're doing now, if you don't mind, my friend.
No, absolutely. Hey, first of all, good morning, everyone. Thank you very much for having me back. I always enjoy the opportunity to come and join and get engaged in the discussion here. I know you mentioned kind of anytime you call and ask, unless of course I'm in court. But don't forget, if that's ever an excuse for me to get out of court, I'm willing to try it. So, I'm open to those suggestions. So the quick background on this. So my firm here, our office, we're based out of Northern Illinois. We're just north of the city of Chicago. I actually practice in Wisconsin and in Illinois. Although we certainly do, when capable, we consult really all over the country on these kinds of issues. My partner Charlie and I actually got together when this firm got started because he had been defending appraisers against me. You mentioned the coming from the dark side idea. I had come out of the state of Illinois, the IDFPR, which is the licensing agency here. I was one of the board prosecutors for about a 4.5 year run over there for all the real estate professions. So brokers, home inspection, auction, appraisal, all of those sorts of things that fell under that real estate silo at the regulatory agency here. I was working on those types of files. I've always been one who has a tremendous sense of self-preservation. And so I was working in transactional work in the late 2000s when everything came to a screeching halt and I needed to go find something else to do. We were doing residential transactions, small commercial work, and I needed to find a new job. I got the post at the state. I started as a prosecutor at the state regulators the week before Bear Stearns collapsed.
Oh,
So you can pretty much just figure at that point the roller coaster ride that was. And then a little over 6 years ago, actually about 6.5 years ago now, I came back out into private practice. The firm here was just up and running. It was only about 6 months old at this point, and we were pulling the people together from a little bit all different backgrounds to do different stuff. And that's when I really came and started working on developing the practice of representing now the appraisers who are watching this type of a broadcast. And that's why I love to get the opportunity to come and do this with you guys.
absolutely, absolutely. And I have a little bit of background in doing helping appraisers. I'm certainly no attorney, but I was an investigator for several years, and so I was. You could argue I was on the dark side too, and it's really not the dark side, is it? I mean, we all have a job to do. So Craig helped the state before. Now he's helping appraisers. I didn't really help the state, but I provided the state with findings of fact, if you will, that were used in disciplinary cases and resolving complaints. And now I kind of like you help appraisers when I can, when they get in those jams. And you're probably like me, if you're out there doing things you shouldn't be doing, don't call me. I'm not going to help you. I don't want them to throw the book at you, for crying out loud. But that being said, we all make mistakes. Nobody's perfect. And right in our standards, it says perfection is impossible to attain and competency does not require perfection. So that's right in Standards Rule 1. So we all make mistakes. I do remember, I told you I'd remember what I was going to say. The primary reason you want to hit subscribe is to know when we're offering these broadcasts. In addition, what you want to do is subscribe, because occasionally we'll have a special webinar, and we're actually having a special webinar next week. So that's kind of a out of our normal routine. We have this one once a month, the fourth Thursday at 10 o'clock Central Standard Time. But occasionally we have a couple of other webinars, and we're having one next week, Tuesday, January 29th at 10 o'clock. Also, I do want to let our viewers know that Craig is open to questions, as am I. So if during this broadcast you have something to say, or if you have a question for the attorney, feel free to type in there, hit send, and we'll get to as many questions as we possibly can. Please remember that these broadcasts are being viewed not only by appraisers, but by users of appraisal services, AMCs, banks. We have regulatory folks watching. I had a Tennessee board member reach out to me. It was very nice. He had watched the broadcast. So we have members of the board of trustees who is a regular viewer of the broadcast. So it's not just appraisers, although I think that's probably the biggest part of our audience. So let's dive right in, counselor. Workfile. What the heck's a workfile? Why do I got to keep one?
Or my favorite question I think I've ever received, this goes back to when I was working at the state. We had asked someone to please send in a copy of the report and work file, and the individual on the other side was kind enough to try to clarify with, now, what exactly did you want to see from that work file? Never mind, you've answered my question.
Yeah, so are you saying that it's improper for appraisers to grab their work file and then try to add stuff to it like 2 years later? The assignment's been done for 2 years. You get that dreaded call or that certified letter in the mail, and it says send your work file. It's inappropriate for me to go back and print MLS listings and create other activity and pad that. We call that padding the file. Am I not allowed to do that?
Well, I would generally discourage you from doing that, and I'm going to give you my reason why. Now, let me say, and the common counter argument to all of this is, well, if it's publicly available data, nothing out there says I actually have to keep it physically located within a folder somewhere. I
Okay.
just have to be able to get back to it if I need it. Okay. I hear that argument all the time. Let me give you another war story. There was a time here in the state of Illinois, a gentleman got called before the state board. He went in to sit with the board and answer for some questions, and the state, in its research and lead up, had also taken a look at available sales that could have been considered in this circumstance. And the state board member asked, "We're looking at the same search parameters. Why didn't you discuss this sale or that sale? Seems like they may have been relevant to consider." The
Mhm.
appraiser said, "Well, my goodness, I'm not aware of that sale. I don't know that that information was available." This appraiser was able to pull the physical piece of paper out of the physical work file, showing the exact search and the search results that he ran contemporaneously when he completed the assignment. You know
Mhm.
what? The appraiser was right. As it
Wow.
turns out, the local MLS had a glitch. The sales that the board member was asking about had closed. Those transactions had occurred by the date of the appraisal. But due to a glitch in the local record keeping in the local MLS, the appraiser would not have been able to see those sales at the time he performed the assignment.
Wow.
So rather than a circumstance where the appraiser now goes up 4 years later, pulls down the same search criteria, prints the sheet now, no sales are there, how do you think that answer to the question goes? Well, golly gosh, I don't know why I didn't consider them. I guess they're right here. I don't know why I didn't.
Right.
Having
Right.
having maintained the actual record in real time saved his bacon on that one because we were able to track that back, take a look at the sheet he had, the sheet that the board had produced in current time, and trace it back to the MLS. And the MLS actually said, "Oh yeah, we screwed that up. That was a glitch. That wouldn't have been there. Okay, we're done here. Thanks for playing."
Awesome. Awesome. Well, I want to let our viewers know that when we talk about this, USPAP says that you can have stuff other places. You just got to reference where that other stuff is. And I'm going to do a screen share real quick if I can do this right. If you guys can see my screen, this is actually the record keeping rule of USPAP. And I'm talking specifically with line item number 277. And it says all other data, information, documentation necessary to support the appraiser's opinions and conclusions and show compliance with USPAP, or a reference to the location of the data. So what that means is, let's say that I've done an analysis of the neighborhood to develop my opinion of the life expectancy, total economic life of the subject property and alike properties. And I'm going to use that analysis for the next 6 months or next year, or unless there's a change in the economic climate, I'm going to have to do it again, right? But I'm not going to do that every time I do an appraisal, for crying out loud. I'm going to do it. I'm going to use the results of that analysis for a little while. And I might put that in a master file cabinet and not put a copy of that in every single work file that I create. But in every single work file, I'll have a reference that my support for total economic life is in the master file cabinet Z in the other room, right? So that's a way that you can do that. And in a little bit, we'll get into digital files, which kind of falls under that because we're kind of getting more into a digital environment, if you will. So, Craig, we asked a survey question, and I'm going to go ahead and just dive into that because we got some interesting answers, and this might lead to a little bit of a debate here. And again, folks, I encourage you to ask questions, or if you have comments that you want to share with us, just dive right in there. So we actually asked this on two different venues. The first one was on our email list that we have, and folks, you can sign up for our email list. A real quick way to do it, if you have a phone out, you can send a text message to 66866 and type the word learn, LEARN, and hit send and follow the prompts, and then you'll be in our email club, if you will. So the first email survey went out to that group. And the question was, how long should you keep your work file? All right. How long should an appraiser keep their work file? Now, I don't know if it was really a trick question or not. But the question is, how long should you, not how long must you, or what the USPAP requirement is. The second question we asked was a little different, but the first question was, how long should you keep your work file? And the first answer was 5 years, and we had 69%. We had 92 people respond to that answer. 5 years is how long you should keep them. Then we had 7 years as item B, and we had 25% answer that. 33 appraisers said you should keep your work file 7 years. Then we had an option of, should you keep it forever? Only 6 people responded to that, or 4%. And then finally, we had an option of get rid of it as soon as possible. And only 2 people answered to that, which kind of surprised me. And I was probably one of them, because I answered my own survey. So there was only 2 people, or 1.5% said that. So 92% of the participants in that survey said 5 years. The next question we asked was a little different. It was worded a little different. And we're going to break all this down for you folks in just a second. The next question we asked on another venue, and I believe this was on the Facebook page, there's like 7,000 members. We had, how long do you keep the work file past the USPAP requirement? And we'll get into what the USPAP requirement is in just a minute. But the question was, how long do you keep the work file past that requirement? And the answers, the options were this. A was destroy it as soon as possible. And it's interesting because on the first survey, we had 2 people, only 1%. On this one, 31 appraisers said, yeah, destroy it as soon as you possibly can. Item B says keep it 5 to 10 years. There were 17 appraisers, and 1 to 5 years. 4 people answered that. So it was interesting when we reworded the question just a little bit, the majority shift from a 5-year period, or even higher, even a 7-year period, to get rid of it as soon as possible. So let's talk about that for just a second, and we'll get your opinion on that in just a minute, counselor. But let's first talk about what USPAP requires. So what is the requirement for an appraiser to keep their work file in order to comply with their standards of practice?
Well, I got to tell you, I mean, this has been one of those issues that I think continually gets revisited. In fact, for anybody who has already taken their 2018 USPAP 7-hour update, which folks were in 2019 now. So I do hope that you've taken your 2018 update, since you've already been theoretically adhering to it for a year. Be that as it may, for any of the folks that took that 7-hour update already and recall a lot of the conversation, or at least I shouldn't say a lot, a significant portion of the conversation in my mind was centered around issues that touch on the work file. Not only are we talking about the final impact of completing the assignment and putting forth your report in whatever format you're doing so, but we've also polished that up to start talking about the communication of assignment results even before we have a fully completed, a fully developed appraisal. Look, and having talked with some of the folks in the standards board and a number of USPAP instructors about this, I think a lot of us recall we've gone through about 3 or 4 cycles of the rewrite of USPAP where we've been debating whether or not to take some sort of a position on drafts. Are we going to have drafts? How are we going to do drafts? And the idea is, folks, we've gone through 4 or 5 rewrite cycles now, and we've never been able to agree on drafts. So we're just going to call it by another name, and we're going to jam it in there anyway. So we don't know anything about drafts. But USPAP now gives you a framework for how to communicate assignment results. Sounds an awful lot like a draft. In order to do any of that, you must maintain a work file to communicate assignment results. So this isn't some get out of jail free card that you can do half the job, send out the info, and then figure out if you need to develop up the full appraisal report, and only then do you need your work file. It doesn't work that way, folks. From the moment you press go on the assignment, you need to start assembling that package, that work file. And in kind of preparing for this webinar presentation this morning, I actually traded communications back and forth with Josh Wallet out in
Oh,
Colorado.
sure, sure.
Josh is on the state board out there now,
Mm-hmm.
also USPAP instructor,
Mm-hmm.
and he said something that, and this is full attribution to him, he said something that I thought was brilliant in its simplicity, but an easy way to remember. Any of you folks in Texas right now, I think Josh is supposed to be teaching on this idea next week down in Houston.
Nice.
So if you get a chance, catch that. One of the things he mentioned that I thought was fantastic, he said in about 3 lines what it takes me 10 minutes to say, is this is Josh's simplified rules for the work file. And there's a lot of nuance to it. It's not just black and white, but it's if you see it, save it. If you state it, support it. And could your work file lead a peer appraiser to similar conclusions? I don't think there's a better way to put it than that.
I
That's
like it.
exactly where you're headed with this work file. If it's you're considering it and you're going to rely on it, or you're considering it and actively choosing not to rely on it, you'd better have a record of it.
Right, right.
If you
Yeah,
are going to
and
make a statement, you've got to have backup for that statement. There's your support.
yeah, and I think maybe we in the past we could have argued, hey, I can provide my opinion. I can call a client and say, hey, I don't think the highest and best use is the present use. What do you want me to do? And they say, oh gosh, stop the assignment if it's not residential. We're not gonna, we're a mortgage lender for residential purposes. If the highest and best use is for development purposes, we're not going to make the loan. Just stop right there. Charge me for your time. And you could argue to say, well, that wasn't an appraisal or appraisal report. That was assignment conditions.
That, that,
I don't have to have a work file.
exactly.
But now
You
you
sure do.
better have a work file. And so again, I'm doing my screen share and I'll show all our viewers out there. USPAP is very clear. This is again the record keeping rule. An appraiser must prepare a work file for each appraisal or appraisal review assignment. A work file must be in existence prior to the issuance. So don't complete your report and then go back and try and create your work file. For prior to the issuance of any report or other communication of assignment results. So now if I tried to call and said, hey, I want to let you know that the highest and best use is something other than the current use, I would have to have support for my opinion of that, and I'd have to have a work file that supported that as well. If I understand that correctly, counselor, that's what that says.
I do believe so. And I think that's an important distinction they've made there. I think there was a lot of focus put into the idea of making that update and bringing that into the 2018 USPAP update and carrying forward because we're seeing opportunities where that level of detail and that sort of information being provided to the client is important, is viable. Now, note of caution on that. If you are somewhere that has somewhat heightened standards, like, say, for example, the state of Illinois, understand that even if you're going to communicate assignment results, even if you're not just transmitting a report, there are additional other state standards under your licensure that you still have to comply with, meaning you still have to sign off on it. You still have to make some assertions, even with communication of assignment results. So, again, understand that USPAP is, as always, the minimum standard to which you must adhere, and various states will ask you to do more than that. Nobody can absolve you of complying with USPAP, but you may have to also do more than what USPAP asks of you. And so be careful. Make sure you are familiar in the state in which you're practicing, or if you're going to take assignments out of state, work elsewhere on a temporary permit, or get licensed somewhere, you'd better be familiar with the act and the rules, the regulations wherever you're practicing, because they may vary.
So I'm on page 10 of USPAP for the viewers out there that have their USPAP on the corner of their desk, which I'm sure most appraisers do, right? Some sleep with it under their pillow. And if you look at, I think only Larry Disney does that. Oh, look, you do too. If you look up here at line item 283, it says what the minimum requirement is. You've got to keep it for a period of 5 years. Or what else?
This is my favorite line in all of USPAP. or at least 2 years after the final disposition of any judicial proceeding in which the appraiser provided testimony related to the assignment.
Hello. I hope everybody can see that. I highlighted it in a different color. So a lot of appraisers get confused on this. And what they'll do is they say, hey, I'm going to take 2 years plus 5 years, and that equals 7. So I've got to keep my work file for 7 years. And that's not what it says, folks. It says 2 years after. So if you are involved in a 10-year trial, if I'm doing my math right, that means I would have to keep my work file for 12 years. If you're involved in a 20-year trial, you'd have to keep your work file for 22 years. So this is the minimum USPAP requirement. So back to our survey, all right? The question was, how long should you keep the work file? And then the other question was, how long do you keep it after that USPAP minimum period? So my take on that, and so this is really just a business decision at this point. As long as you've met your minimum requirement, if there's no judicial proceedings, 5 years is the minimum. So 5 years and 1 day, I've met my requirement in accordance to USPAP. As long as there's no state laws prohibiting, I can actually destroy my work file. Now, the question is, what are you appraisers out there doing? And so we're going to get Craig's advice or his opinion in a moment. My opinion is get rid of that sucker as soon as you can. And please understand, I'm not advocating poor behavior. I'm stating that we all make mistakes. You know, I took handgun training one time, and the police officer said, you know, if Craig's coming at me with a knife and says, I'm going to kill you, I'm going to try to stop that threat, right? I believe it. When the police come, I'm not going to talk to them. And I thought that was very bizarre. Here's a police officer saying he's not going to talk to the police. But he said, when they say anything you say can and will be used against you, they mean that. And so it's kind of my analogy that anything that's in your work file or something that's not in your work file that should be in your work file can and will be used against you. Now, this is more from a regulatory standpoint, and my consulting assignments have helped more. I have had some civil issues as well that I've consulted with, and one criminal. But most of the consulting I do offer for appraisers stem with regulatory issues, right? And so that's where my recommendation is, getting rid of that. I always say I can't remember what I had for dinner last night, more or less what I did 6 years ago. So you're pulling a file on something I did 6 years ago, and you want to bring me in and question me on what I did or maybe what I didn't do. My answer is, in all honesty, I don't know what I did or didn't do 6 years ago, right? So let's get the attorney's recommendation. I know an attorney that recommends you keep a period for 10 years, and I think that's for civil and criminal purposes. And you can't differentiate. You either have your work file or you don't. But I'm eager to get Craig's position on that. And if anybody has any questions or wants to chime in, feel free to do so. We do have some questions coming in now, but we'll hold those. Craig, what say you for the length of time? What's your recommendation to our viewers out there? How long should they keep their work file?
Well, that's a great question. That's probably one of the most common questions that I get about workfile. It immediately goes to, how long should I keep it? And I'm going to give one of my patented answers that I think Tim Anderson might have given you last time the two of you spoke, which is, I'm going to give you the old, it depends. Now, here's the idea behind that. And look, I understand, Bryan, exactly what you're saying about anything you say can and will be used against you. There is a truth to that, just like anytime you are in an adversarial situation, if you are dealing with the state regulator, look, I used to be one. We might be nice, we might be cordial, we are the opponent in that circumstance. If you are involved in civil or criminal litigation of some sort, that is an adversarial circumstance. Understand, in an adversarial setting, anybody on the other side of this equation is going to try to use your own words against you. Which is why I'm actually somewhat boring sometimes in the answers I give, because there's a chance somebody could pull up this YouTube video and jam it back down my throat 5 years from now.
Right,
Okay.
right.
It's the reality of the world we live in, and especially in the area of practice that I'm in, you have to be very cognizant of that sort of thing. So I understand the perspective of immediately destroy it as soon as you are legally permitted to do so, because that way they can't use it to hurt you. I get it. I don't encourage that, but I understand that perspective and I understand why. You mentioned the 10-year idea that had been referenced by somebody else. I can
Right.
give you a little bit of a sense of where that comes from. You already touched on USPAP, minimum standard, 5 years, or the +2 standard, which actually is worded horribly and it's nebulous, and I've never actually gotten a straight answer out of anybody for what that truly means. That aside, different states will also have different standards for that. Many of the states, as they've adopted USPAP for regulatory purposes, will also state 5 years on the work file. And for regulatory cases, sometimes they'll even put in a 5-year statute of limitations on a license complaint, because they figure if you're only going to keep your work file for 5 years, we're not even going to be able to get the data and the information we need to potentially sustain a licensing complaint outside of 5 years if you've destroyed your work file at 5 years and 1 day. That's just one aspect of this. If you're getting charged civilly with something, most states have a statute of limitations for a negligence claim between 4 and 7 years, and it varies by state. So you need to be familiar with the standards, the rules, the regs in the state that you're in, and make a decision accordingly. That 10-year statement comes up because in many states, this is much more consistent. A breach of contract claim is often limited to a 10-year statute of limitations. And so that, I think, is about where that number starts to come from, is at the 10-year mark, you've likely gotten to about the end of the chain for somebody to file a civil action against you under some theory of liability. My answer is much more complex. I don't have a bright line 5-year, 7-year, 10-year. I don't even have a forever rule. My answer to everyone who's viewing this, and first of all, this isn't legal advice, and we don't have an attorney-client relationship.
Absolutely.
But my anecdotal evidence that leads me to having an opinion about this: form a policy that makes sense for you and adhere to that policy. Every time I speak in front of a group of appraisers, whether the content has anything to do with Workfile, I am always asked a question about the Workfile and how long you should keep it. It doesn't matter. I could be talking about something wholly unrelated. Somebody in the audience is going to ask the Workfile question. I don't know if people realize this, but something like 80% of appraisers all fell victim to the Great Flood. And you might ask, what is the Great Flood? The Great Flood is this one flood that at various points in time, just the water swells up out of the ground and attacks an appraiser's office and sweeps away the one box of files that contains the one work file that the state investigator's asking for, or the lender's counsel on the buyback litigation, or whatever it is. But all of these appraisers have all been hit by the same flood, geographically various locations and in all different years. But this one flood has taken out an overwhelming percentage of the appraisal work files out there. That's not good enough, and it causes more problems.
Right.
You're better off not having any of your files anymore than just missing the one file that someone's asking you about. Okay.
I've got every file I've ever done except the one that I just got the complaint on. Right?
It's amazing how that happens.
Yeah. And we'll talk about the ethics associated with that in just a second. But we're at the halfway mark. Unbelievably, we're already at the halfway mark of our broadcast. We do have some questions coming in. Thank you you for all you asking questions, and keep them coming. We're gonna bog him down here in just a minute and ask him some tough questions, see if he can answer all of them. My name is Bryan Reynolds. You are watching the Appraisal Report webinar, brought to you by Appraiser eLearning. It is a free webinar that we offer once a month, the fourth Thursday of every month, at 10 o'clock Central Standard Time. We're happy that you're here. We invite you to come back. Go back and look at some of the past episodes. I think you'll find them very interesting and maybe even useful. If you would like to be on the show or know someone that you think would be great in the hot seat, drop us a line. Call Ben, Doug, Jim, Hal, or myself, and we'll reach out to those parties and try and get them in. If you haven't done so already, subscribe to our YouTube channel. I said a moment ago, we do occasionally have special webinars, and we do have a special webinar lined up for next week, next Tuesday at 10 o'clock Central Standard Time. I believe that's January 29th. We've got a couple of folks on, and we'll be talking about the upcoming ACTS conference and what that is, where it's at, why you might be interested in attending. So check that out. Again, all of our webinars are recorded, so if you have to jump off here and go do an appraisal or do something else to make some money, we certainly understand. You can come back and watch the recorded version at a later time. So my guest this morning is Craig. He is an attorney in Illinois, and he helps appraisers that get in trouble get out of trouble, or at least that's the goal, right, Craig?
I like to help appraisers who have helped themselves stay out of trouble and or dig their own way out of trouble. I'm only as good as the material I have to work with, and much of the material I have to work with is located in your work file, folks.
He's not a magician, you know, and that's what when I help consult with appraisers, you know, if there's a valid alleged violation, if you will, I tell them, guys, I can't magically make this appear in your report. I can't magically make it appear in your work file. We may have to raise our hand and say you made a mistake and take our lumps on this one. Let's beg for mercy. But there's other times that we can approach it from a different aspect because, listen, regulatory board members, they're just people too, and they can make mistakes too. So a lot of times it's just really, let's see what happened here. We understand why the person that filed the complaint has had a knee-jerk reaction, okay? But let's look at the truth here. Let's look and examine it, what the appraiser did, what the appraiser didn't do, and while maybe in this case they didn't do it the way I would have done it, they didn't do it the way you would have done it, did they violate USPAP? Because really from the regulatory standpoint, that's the bottom line. We're not talking about best practices. We're talking about, did they meet the bare minimum of USPAP? And a lot of times you can have some success along those lines. So let's talk about some of the deficiencies that you see, Craig. I think a lot of our viewers would be interested in that. Sometimes they get a little clouded. Do I need to keep every piece of paper and every conversation? You know I got a subpoena dus tecum. I don't know if I pronounced that correctly, but I got a subpoena dus tecum one time. I didn't even know what it was. And they asked me for like 27 items. And of course, they wanted my work file. They wanted a phone record of everyone I ever talked to on this case. It was pretty intimidating because it looked like it came from the court. And later I realized it was just an attorney, you know, requesting it. But it got my attention. I'll say that. So what should an appraiser look for and make sure they're doing when they get done with this broadcast? They go grab their work file and look and say, yeah, I've done what the attorney says. What's the top 3 or top 5 issues you see routinely as far as deficiencies in the work file?
The most common thing that I see that is lacking from a work file, and this, I can't really explain why this is the case. This seems reasonably simple to me, but I most frequently see circumstances where the search criteria. So if we're doing a sales comparison approach, the search criteria, the data that is actually filtered by the appraiser for their consideration, is not adequately preserved within the report. Sometimes, and within the work file, I should say. Sometimes we're not as concerned with the 3 comps you chose. Sometimes we're concerned with what were the other 14 you decided not to use. you might be right, but unless you can show me what they were and give me some indication that you did in fact consider those other sales, and we see what the parameters are, so we see the level of data you were considering when comparing them to the 3 or 4 or 5 you chose to go with, we might not be able to know why you left one out. We might not know in some circumstances why you came to some of the adjustments you came from. Where'd you get your adjustment from? Well, I pulled it out of the market. Oh, do tell. What
Yeah, yeah,
what market are we talking about? Do you have something that supports that? And I think that goes to Josh's statement about support. If it is if it is information that is leading you to a conclusion, whether it's information that you rely on or information that you are aware of and choosing through your own analysis, you get to do this, you're the expert. You're choosing not to rely on that information, but another one of your peers or a regulator might also see that information and wonder, gee gosh, why didn't you choose to include it here? If it's that, you need to preserve it so that you're prepared to answer that question if it comes. Can somebody else produce the same? And I'm not talking down to the dollar. I mean, I
sure,
love it when you see
sure.
people get down to it was, this many $1,301.17, and nobody's
Right,
that good. I mean,
right,
round it to 500s or thousands for all I care. You don't
right,
have to drill down to that level of granularity, but somebody else should be able to step in your shoes, pick up your file, and replicate what you've done, or at least understand how you got there. They might not agree with you, but
right,
they might
right.
be able to look at it and go, oh, but I get it. Because those are the same questions that the investigators, that the board attorneys are looking
Mhm,
at. That's
mhm.
always what I look at. Do I understand why you did? I don't have to agree with you.
Right,
Do I
right,
understand why you did it? The only way I can know if I understand it, I have to see it in the file. It's the comps selection. It's the metrics you're using. Good grief. If when you're doing a standard old 1004 or something like that, and you're doing your market conditions, please, please, please include your analysis of the market conditions in your work file. That single page MC form is bad, has been bad, always will be bad. You
mhm.
have to be able to step around that to come up to any discernible trend and analyze it. That information should be somewhere in your file, or at least identified and referenced so you can get back to it.
Right. You know, it's interesting, and two things that you spoke on. I want to touch on. One is the adjustments, if you will, and there's several recognized techniques to support your adjustment. And so, just saying it's your opinion doesn't cut it anymore. People, Fannie Mae are sending letters out to appraisers. Uh, certainly in the courtroom, they're going to want to understand how you came to that. Yes, it's your opinion and you're entitled to your opinion, but what are you developing or what are you basing your opinion on? That's the critical answer there. I just spoke at a real estate office here locally in my town, and of course I picked a great easy subdivision where there were a lot of sales, and we have a subdivision called Thoroughbred Acres, and the exact same house, the model is called a Gulf Stream. So, it was very easy to have a dozen Gulf Streams, all the exact same size. And we were able to extract through paired sales. Yes, I said paired sales, a range of what a car storage would be, right? Now, what number do you want to use within that range? Well, that's part of your reconciliation, and you get to choose that. The sharpest tool an appraiser has is good judgment. So you need to invoke a little common sense and use good judgment in that reconciliation process. But as long as you're using something there, you have support. Here it is in my file. This is what I base my opinion on. You may not agree with it, but you asked me how I got it, and this is the answer. This is how I got it. So the other thing, the 1004MC, I agree, that's a dumb form. The form contradicts itself. It asks for the universe of sales in a neighborhood, and then in the instructions, it says, I want you to use comps. We got to get to some questions here in just a minute, Craig. I do want to, on that 1004MC, I want to give you a real live example. There was a colleague of mine that was testifying in a case, and now he spent an enormous amount of time because he was trying to do a good job for this new attorney client. So he spent a tremendous amount of time. But when the hearing occurred, when the trial occurred, the other expert was asked, why did you put down that it is a stable market? And the appraiser just said, well, that's just my opinion. I said, well, we understand that's your opinion. What do you base it on? He said, years of experience.
My favorite, because that's how we've always done it.
That was his answer. So when my friend got up and he was testifying, and he says, in my opinion, this is a rapidly declining market. And I said, well, what are you basing your opinion on? And he said, well, here's photographs of houses up and down the streets showing up, boarded up houses. Here's the number of foreclosures. Here's the properties that are currently listed that have been reduced numerous times, and they're selling for less now than what they were bought 2, 3, 4 years ago. The days on the market are 400 days. Everything is indicating that this market's in a state of decline. And so it didn't take the jury a long time to render a verdict in that case. And that's just an example that having that data, you are entitled to your opinion, but you got to base your opinion on something other than saying years of experience. That doesn't work. I'm going to ask you some questions. We've got some questions rolling in. So Mary Beth, ask a question. My partner, who handled the commercial aspect of our company, passed away in 2014. My sympathy goes out to you, Mary Beth. I hate to hear that. I did not sign any of the commercial reports, as I only do residential work. How long do I have to keep his files?
No, that's a fantastic question. First of all, I'll echo the sentiment. I'm terribly sorry you have to go through that. That's a hard circumstance, no matter which way you slice it. To the question itself, there's a couple of different layers for that. If we're talking from a regulatory or a licensure perspective, and forgive me, I'm going to be a little bit dry about this. You are not obligated to keep his files for licensure purposes, because it's not your license that's at risk, and his is not at risk of being disciplined at this point. There is no, from a state regulator's perspective, that there is a hard stop on any attached liability at that point. From a business concern, you mentioned in the question the word partner, which leads me to indicate that the business relationship, whether it was a corporation or a partnership or whatever it might be, you both had ownership or managerial stakes in this business. That's a separate liability question, because these could be the subject of civil liability to the organization, to the firm. And if that's the case, then what you need to consider are, now it's not that 5-year rule licensing question. It's a matter of, is there a statute of limitations in your state on negligence? Is it 4 years? Is it 7 years? Is it that 10 years for contract? I would, out of abundance of caution, I would discourage you from destroying anything too soon, because it may be of value. However, you're probably right in the sweet spot right now, where some of those files almost certainly are going to be older than 5 years. You would not be able to competently testify about the contents of any of those assignments if you did not work on those assignments. The best you're likely to be able to do from a business perspective is state, if you have personal knowledge, yes, we did that assignment as a company. No, we did not do that assignment, because you're only doing the residential work and you're not involved in the commercial work, just like presumably your partner was only doing the commercial work and was not involved in your residential practice. He would not have been able to testify to the quality or content of your work, just like you wouldn't be able to testify to the quality or content of his work. From that standpoint, there's no benefit to holding onto the files. You're not going to be able to independently verify, well, did your partner rely on this data or not? How would you know? You didn't do it.
Right.
So you've got some protection there, in that you just simply cannot be the person most qualified, or the person with most knowledge, which are a couple of legal terms, to testify about the quality of the content. That said, the only hook you have on any of this is, what is the remaining exposure to your business venture at this point, and that's really the only consideration you need to make, because it's not your license we're talking about here, and it's not any of your work product. You can't get asked those questions, or rather, you shouldn't be required to answer those questions by any competent court, and any counsel worth their salt in any way is not going to allow you to field those questions. So I realize that was kind of a meandering answer there, but it's all about how the question is framed. It is a pure business question at this point. It's not an individual liability question, because it doesn't pertain to you as an individual, and hopefully that gets you pointed in the right direction there.
Thank you, Craig. Thank you, Mary Beth, for that great question. That's why I love this guy. You know, I mean, that was my answer exactly.
in exactly as many words. Remember, I get paid by the word, folks.
So Bonnie asked a question, Craig. Bonnie is asking a question. She said, even if there is no trial, but the report was turned in to the state board for review, are we then responsible to keep the file 5 years past the state board dismissal date?
Can you pull up, Bryan, that section on record keeping again from USPAP?
You bet. It is right here.
That's me.
Oh, sorry. You know, I'm not the technical guy here. How'd that happen? Okay, let's try this one.
Let's go to that one. All right. So look at the green highlight, folks. That's a fantastic question, by the way. Thank you for bringing that one up. Understand again, for the answer we're going to give you here, this is specific to the language of USPAP. Your individual state requirements may vary. So please, at least once a year, pull out your state license law and your rules and review them, because you're responsible for knowing it. Now, back to the question. Look at the green highlighted portion here. It's 2 years after the final disposition of any judicial proceeding in which the appraiser provided testimony related to the assignment. So, specifically to your question, if there was no testimony given, and that is honest to goodness, raise your right hand, do you solemnly swear testimony? That's not somebody asked you a couple questions about it. That's real live testimony, whether it's a deposition or testimony in a live courtroom. It's 2 years after the disposition of any proceeding in which you raised your right hand and swore, okay? That's what that means. So if it's just an investigation, if it's just a complaint, under purely USPAP, that does not, your circumstance would not fall under that category. So 5 years past the state board's dismissal, if no testimony was given, it's irrelevant. You're still using the 5 years from the date of the assignment itself. Where I will again throw a little bit of color on this one and caution you in that regard is, if there was any sort of a testimony, that now triggers this secondary clause, and your own state may have a specific requirement that involves a state investigation, or may modify this USPAP standard some. They can't go any less than USPAP, but they can always dial it up from there. And so you need to be familiar with it. And this gives me a second to jump up on my soapbox here about that idea of what a final disposition is. And I'll be brief, because I want to get to the other questions as much as we can. But nobody has ever sufficiently answered for me the question of, what do you mean by a final disposition? Is it the ruling at the trial court? Is it the ruling in the appellate court that considers the trial court, that sends it back to the trial court for a retrial, and you tee this up again, but you're not bringing in any new facts or evidence? You're just left to reconsider the evidence that's already in. Is it the second time it goes up on appeal? After that, is it the time it goes up to the Supreme Court or gets sent back down for an additional ruling? Which one is the final disposition? And I can tell you, there is absolutely no consensus as to what that means. So I think that's poorly worded. And unfortunately, a lot of states have taken that exact language and ported it over into their own license acts or whatever. And I think it actually creates a gray area that it's likely infrequent enough that I don't see somebody fixing that problem anytime soon. God knows I raise it every cycle we go through. But it is of concern to me, because I like certainty, or rather, I should say, I fear uncertainty. And I don't know what that means, and I haven't had anyone yet tell me what it truly means. So that's always something to be cautious with. Out of abundance of caution, if this is a file that ends up in litigation, go forward. The hook on that one, you destroy your files at 5 years and 1 day, and 7 years from now, 10 years from now, you get sued and you're forced to testify in that lawsuit about the work that you did. Does USPAP refire up and say, well, actually, you should have had it 2 years past the time you testified, even though you destroyed it at the 5-year mark because you hadn't testified yet? I don't know the answer to that question, and nobody else can give you a competent one.
You know, I want to go back real quickly about the work file and the flood that you mentioned, and caution appraisers. You know, years ago, the record keeping, there was no record keeping rule. Record keeping fell under the ethics rule. And this is kudos to the Appraisal Foundation because they really solved some problems here. Because think about it for a minute. Let's say you're a practicing appraiser and a real flood does happen, okay? Or your office burns to the ground, okay? All your work files are burned up. They're gone. And let's say, God forbid, you get a complaint filed against you on something you did 2 years ago. Are you supposed to have the work file? Yeah, you're supposed to have the work file. And you go to that regulatory board and you say, hey guys, I got bad news. My whole office burned to the ground. All my files were burned to the ground. Well, old USPAP didn't care. It fell under the ethics rule. And so if the board came back and hopefully they would be somewhat understanding under those circumstances, but they could come back and say, well, guess what, appraiser, you should have had fireproof file cabinets, or you should have had a duplicate, you know, offsite or whatever. If they chose to discipline you as a consequence, you would then have a violation of the ethics rule, which is horrible because ethics is something you know right from wrong and you're choosing to do wrong, right? Or correct? That's exactly what ethics is, okay? So the record-keeping rule that the Appraisal Foundation came up with was a good thing for you and I. But then somebody came up and said, hey, what about this? What about it is that one appraiser who has all their work files and then they get a complaint and they take their work file out and they burn it, right? That would be an ethical issue, wouldn't it? That might also be considered obstruction. I don't know. I don't know. You tell me. So they added a provision, and I'm going to go back to my screen share real quick and show that. At the very bottom on line item 297, it says, an appraiser who willingly or knowingly fails to comply with the obligations of the record keeping rule is in violations of the ethics rule. So if you burn that one file up in an effort to try and hide evidence or get rid of it, you're now violating the ethics rule. If you have a policy in your office that I'm just not going to keep work files, you know, I'll just roll the dice, take my chances. I'm save a tree. I'm not gonna have a work file. Then you're violating the ethics rule, and you need to be real careful with that. You need to do the right thing. So a couple more questions, Craig, and we're about to run out of time, but let's get to a couple of these real quick. Ryan says, you get sued 7 years from now. How are you going to defend yourself if you have no work file that shows you were in compliance? Save it for 10 years. It's just good security. Thank you, Ryan. I think that was more of a comment than a question. So Pamela, excuse me, I call her Pam because I know her personally. Pam asked a question. Would you foresee USPAP in this day and age requiring digital storage off-site? That kind of goes in hand with the fire or flood we talked about. Craig, what do you think about that? You think USPAP at some point will dictate that the appraiser needs to have some sort of off-site digital storage, the cloud, for crying out loud?
I expect that see that level of detail input into either a USPAP. I don't think the foundation or the Appraisal Standards Board necessarily wants to go down that road. I don't think you'll even see that at the state level necessarily. Most of the time, the oversight and the regulators are loath to tell you how to truly conduct your business. I mean, their focus tends to be on the public. We're going back to public trust here.
Right.
We're going back to touching the consumer in your sense. It's touching them with your information, with your product. I always tell people licensure structures, understand this. If you're in a profession that involves you touching another human, you probably need a license, and the licensed activity is going to be the part where you touch someone. If you're touching someone else's money, you're probably going to need a license, and the licensed activity is the part where you're touching their money. For your circumstance, the part where your license triggers, the part where USPAP really covers, is the part where your information, your product, your knowledge is touching the decision-making process, the security of another party. Okay. So they're likely not going to tell you how you have to maintain your records. They don't care about that part. They don't care if you're a W-2 or a 1099. They don't care how or if you pay your taxes. They don't care if you keep it in a box or in the cloud. They make you keep it for the 5 years because the basis of that knowledge, your support, your foundation, impacts the decision making, the security of another party. That's why they make you keep the work file. To answer your question a little bit more closely, I'm gonna put this towards the camera and see if anyone can see. Does anyone know right now what I'm holding? It's a little bit of a trick question. What I'm holding right here is a law firm. Okay, this is us. What you see in my hand here is the Franklin Law Group. Everything we've got from the moment we started conducting business as the Franklin Law Group is right here in my hand. Okay. I do not expect regulators to tell you you have to use this, you have to use the cloud, you have to have various redundancies. Those are all business decisions. But I'll turn the question back and I will say, if you are called regulator, if you are called in a civil setting and asked to produce your records, produce a file, and your answer is, oh, I only kept everything in this one box and it's all gone now, they might ask you, why didn't you consider using something that's readily available to you? They're not going to tell you you have to, but you're not going to get any credit from them if you're not availing yourself of the technologies, the systems that are around, various redundancies. Things you wanted to touch on a little bit here was the idea of keeping a digital file. I promise you there's not a single appraisal work file on the planet that is any more dense and contains any more data than the stuff that I have contained right here. Okay? It's not. First of all, because I've probably got 3,000 or 4,000 appraisal work files on this, along with all sorts of other insurance stuff and other legal documents and the like. We're running out of reasons why we are unable. You don't have to have that 24-hour secured, climate controlled, offsite facility. In the event of unrest in a civil and South American nation, you'll still have the 6-month reserves of access to those days are gone and over. They're not going to force you into it, but we're really running out of excuses. And the more tools that come online with various technology and support platforms that almost build your work file for you with each click, each press of a button, each upload of a document, there's no reason why we shouldn't have this stuff available.
Yeah, we really need to consider using the automation and the technology that's readily available to all of us, whether it be a digital clipboard out in the field. I mean, you all use digital cameras now, I hope. Even this broadcast you're watching, these are all tools that we can get together once a month and have a conversation about what's going on in our profession. These are tools that are readily available for us. And I'm a little guilty. I'm trying to make that transition. I will say this. I was back in the day, I had 15 file cabinets that were along our wall, and I'm down to 2 now. So we're not 100% digital in our work files, but we're real close. And that's our end goal. Craig, we're out of time. I can't believe that it just flies by. We literally could make this about a 3 or 4 hour webinar, I'm sure, because we just really kind of scratched the surface on this work file stuff. Tell everybody, if they're interested in getting in touch with you, how they may do that. And again, remind everyone where they could actually come see you live, if you don't mind, my friend.
Thank you. First of all, thank you everybody who joined us today. I appreciate the opportunity to sit down and talk about this stuff. Believe it or not, I really enjoy this part. Thanks, Bryan, and all of you at Appraiser eLearning for reaching out and having me come on board. If anybody would like to reach out and contact, we are the Franklin Law Group in Illinois, based out of the north suburbs of Chicago. I are one of the attorneys here. You can reach me directly at my email address, which I'm trying to think if we have that up. If not, I'm going to send it right now through the back channel, but I'll also read it off to you. It is my first initial and my last name, CCAPILLA at charlesfranklinlaw.com. I know that's a complicated one. I apologize for that. You can also find us on the internet at charlesfranklinlaw.com. And our phone number, it's an 847 area code out of the north suburbs here, 847-716-2380. Please, folks, if you ever have any questions or concerns, do not hesitate to reach out. We'll help you out in any way that we can. And if you need counsel and we can help you find the right counsel in your state where you're at, we are happy to do so.
Thanks again, Craig. I appreciate it. And guys, he's just a good guy. He's a fun guy. He's a good guy. I try not to tell too many attorney jokes when I'm around with him, but he's got thick skin. He can take it. So if you do need him, feel free to reach out to him. He's posted the information there for you. Thank you very much, Craig, for being here. Thank all you viewers for coming in this month and checking out our webinar. Don't forget, we do have a special webinar next Tuesday at 10 o'clock Central Standard Time. And then we're back on our regular cycle. Mr. Jim Park from the Appraisal Subcommittee is going to be with us next month. We're super excited. How often do you get to participate and even type in and ask real-time questions with someone from the Appraisal Subcommittee? Probably never. So here's your chance. If you've got something to say, if you want to learn more about what they do, if you have a gripe or complaint, this is a format for you to get involved, make a difference. Thank you again for watching. My name is Bryan Reynolds. This is the Appraisal Report webinar brought to you by Appraiser eLearning. Have a great day. We'll see you soon.
Thank you all.